Welcome to Juris Stupidity, a podcast devoted to drawing attention to the misuse and abuse of legal concepts and terms. This episode is about absolute constitutional rights or freedoms. Undoubtedly, you have heard self-proclaimed experts and other know-it-alls who assert and banter about claims of an absolute constitutional right. Well, newsflash. Under the United States Constitution, there is no such thing at all, and never has been. You see, any, and I mean any, constitutional right or freedom can be limited and regulated if a compelling state interest is served. In practice, the level of interest served by a limit or regulation is established by the courts and then thereafter guided by application of stare decisis, a concept that I will cover in a future podcast. But for now, think of it as a judicial principle to follow the legal rules in prior similar cases. For now, consider that when you hear claims of absolute right or freedom, you can be assured that the speaker does not know what he or she is even talking about. I will give you a few examples of limitations of constitutionally protected rights. Such an example is the right to free speech under the First Amendment. There are numerous cases stating limitations to free speech. And generally, free speech is highly protected, such as for a protest march. But such speech can be limited by restricting it from certain locations, such as near hospitals, schools, or busy intersections. Moreover, verbally abusive epithets and offensive conduct that are inherently likely to provoke violence may be banned altogether. Even the exercise of religion, protected under the First Amendment, can be limited. For example, a claim that one's religion prohibits taxation of individuals in that particular religion has been found to be limited, and in such a case involved an Amish employee who asserted paying taxes violated his exercise of religion. The Supreme Court said, quote, "Not all burdens on religion are unconstitutional. The state may justify a limitation on religious liberty by showing that it is essential to accomplish an overriding government interest." End of quote. The United States Supreme Court has made the limitation of rights clear in a Second Amendment case, saying the Second Amendment conferred an individual right to keep and bear arms. Of course, the right was not unlimited, just as the First Amendment's right of free speech was not. Thus, we do not read the Second Amendment to protect the right of citizens to carry arms for any sort of confrontation, just as we do not read the First Amendment to protect the right of citizens to speak for any purpose. So when you hear assertion of some absolute constitutional right or freedom, just prepare yourself to hear a lot of blowhard blather.